Yes, Mr. Howard.
May it please your Lordship. The issue in this appeal is whether the appellants, as assignees of Oak Finance, are entitled to sue Novo Banco on the basis that it's party to a facility agreement with Oak Finance containing an English jurisdiction clause. Now, it's common ground that the appellants made their deal with BESH, a Portuguese bank, and not with Novo Banco, and it's BESH on whom they did their due diligence and BESH to whom they loaned the money. Within days of the Oak Finance deal, which was concluded on the 30th of June 2014, BESH ran into financial difficulties. As the decision of the 3rd of August 2014 reveals, as a result of severe losses incurred during July 2014, it faced a liquidity shortfall. It was effectively insolvent. If matters had stopped there, the appellants would undoubtedly have been left to their rights in the insolvency of BESH. However, the appellants seek to avoid the effects of their unwise decision to lend money to BESH by claiming that effectively the Portuguese taxpayer has come to their rescue in the form of Novo Banco. Now, Novo Banco is the creation of BDP, acting pursuant to its powers under Portuguese banking law. The decision on the 3rd of August to establish Novo Banco and the decision also to transfer certain assets and liabilities of BESH to Novo Banco was an administrative decision taken by BDP as an administrative authority in Portuguese law. Now, exercising its powers under Portuguese banking law, BDP transferred the liabilities of BESH to Novo Banco with certain exceptions, including a class of liabilities owed to shareholders owning more than 2% of the equity of BESH. The inclusion of such an exception was a requirement under Portuguese law. Now, as you know, in December, an issue arose as to whether the liabilities to Oak fell within this excluded class. It's fair to make the following observations at the outset. Firstly, the decision of the 3rd of August was done as a matter of urgency in the light of the dire financial circumstances of BESH and the capacity for contagion should it have failed. Secondly, plainly as you will see, BDP had the power to select which assets and liabilities were to be transferred. The oddity of this case and of the appellant's approach is this. First, if BDP had specifically excluded the Oak liabilities from transfer on the 3rd of August, there would be no issue. It would be common ground. The liabilities would not have been transferred, even if the decision could have been challenged in Portugal. Secondly...
Can you just help me? They had to exclude, there had to be an exception, and they had to exclude 2% or more liabilities.
Yes.
But they could have excluded others, is that what you're saying?
Well, there are a whole lot of things they could have excluded. But
I mean,
yes.
They could have added, is that in the August decision itself, or is that something they would have had to have done by changing the terms of the August decision?
Sorry, I'm not sure.
I.e., does the August decision give them any discretion as to what was transferred as opposed to stipulate what was to be transferred and provide certain exceptions? The
August decision, you have it in Core 2, tab 17. If you go to page 453, what you see is what they did was transferred in point 2. Point 1, they set up Novo Bank, and point 2 was transferring assets, liabilities off balance sheets, and so on. That was as listed in Annex 2 and 2A. It's actually important to note that Annex 2A, which you see at page 468, was a provisional balance sheet, described as preliminary. And I'm going to show you what happened next it's important to understand that there wasn't just the decision in December, there's another decision in August, as you would expect with this sort of process, whereby the central bank has to consider matters further as it goes along. So it had to consider what I think it describes as the perimeter of assets and liabilities.
So it doesn't actually appear to have been discretion. It was an attempt to define in Annex 2 what would be transferred, and Annex 2A is an attempt to crystallise that in financial terms. Yeah.
Yes, I'm not saying that they retained, if that was your Lordship's question, a discretion,
No.
but the simple point I was making was that as a matter of Portuguese law, and this much is common ground, if on the 3rd of August they had specifically said the oak liability is excluded, either simply said that, or they had said it's excluded because it falls within the exception which your Lordship sees at page 464, the excluded liabilities at the bottom of the page. You can see there are a whole lot of excluded liabilities. So if they had said, because at that stage they hadn't considered specific liabilities as to whether they were...
They could have identified this as the oak liability is not included in this category. And also I notice on 465, after the transfer, of course, there's the provision that Banco de Portugal may at any time transfer or transmit assets, so to speak, back.
Yes, exactly.
So that what they said was push everything over except the accepted stuff now, yes, but we may want to think about it later.
And when you come to look at December, I'm afraid we've got to look at these decisions a little bit more closely. Yeah. You'll see that there's a report, which I think you weren't shown, which explains we didn't know the facts about this particular liability. And that's what they weren't looking at specific liabilities. What they were looking at is a bank that's about to collapse in August. And so what we've got to do is set up a bridge bank, essentially to protect both Portuguese and the Europe-wide banking system. Obviously, if a bank collapses, we all know what the consequences can be. As a matter of Portuguese law, they were required to exclude certain liabilities. That's what they did. Then they come back in both August and December to consider how that actually works. But the point I wanted to make just by way of introduction at this stage was a slightly different one, which is assume in August the question had been before the committee of the bank as to whether oak liability fell within the excluded class. And they had said, as they did ultimately in December, it is not transferred. It's common ground that if they'd said that in August, that would be binding for these purposes. Although it would be something, they'd still be entitled to pursue, when I say they, Goldman Sachs et al., would be entitled to pursue their rights on appeal. And so what the question is at the outset, does it make any difference whether BDP made the decision on the 3rd of August that the oak liability fell within the excluded liabilities, or the 22nd of December? The appellants say that it does. We say that's misconceived and relying on a distinction without a difference.
So where's your authority for the proposition that they could have said in August, don't put that liability in Annex 2A, and that would have been binding?
In this sense, I mean, it's simply how this isn't really in dispute. They have the power to make an administrative decision. It's not in dispute. They have a power to make an administrative decision as to what is and isn't within the scope of the excluded liabilities. And so they could have done that in August. The complaint is that they didn't do it in August.
But that would have been done, would it, by reducing one of the items in Appendix 2A, or,
yes.
Or how?
It could have been done in any number of ways. It could have been done by, in the decision itself, you could have had point 2A, you could have said, this doesn't, within the excluded liabilities is the oak liability, which would have meant then the balance sheet would have looked different because you'd have taken $800 million out of the...
Well, I mean, if you actually had a specific item, then that would be a specific exception, and there wouldn't have been a right to go to court. What you were
There would have been. No, there would have been. Absolutely. Look, this is one of the fundamental misunderstandings which I perhaps ought to correct straight away. The August decision itself is being challenged in Portugal. And it is an administrative decision which is being challenged. And
under the general provisions relating to administrative law, like any administrative act.
Yes, not by these parties, but by other parties who complain about the effect.
It's being challenged, as I understand it, not under some legal provision specific to bank reconstructions or this bank reconstruction. It's being challenged simply on general principles of administrative law applying in Portugal.
Yes, I mean, all the challenges in Portugal are under Portuguese administrative law.
General Portuguese administrative law, not the specific bank reconstruction provision.
Well, I'm not sure I know the answer to as to the specifics of that.
Can I just ask about the power that was being exercised by BDP when they were doing this in August?
Yes.
It was under Article 145H.
Yes, I'm going to take you to...
And that says that they can select the assets, but there are certain parameters that they can't go outside,
exactly.
And that's the problem with this particular transfer, potentially. So is that an unfettered power to select, subject to those particular boundaries?
I'm not sure what the answer to that is as to whether they have, as a matter of Portuguese law, an unfettered power, in fact.
But enough to have said this oak debt is excluded?
Yes.
Right.
Can I just be clear in case there's any confusion? When my learned friend says the August decision is being challenged, the committee should not think that it is being challenged by the Goldman Sachs or my clients.
No, of course it is.
No, they, of course, they don't challenge it, they seek to embrace it. But there's an important point, which is somehow a distinction was sought to be drawn. Well, the December decision is subject to challenge, and that somehow means it's of a different character. Any decision by an administrative authority, in the same way any decision by the equivalent here, can be subject to challenge. Doesn't mean the challenge will succeed, and it doesn't mean that the decision is not binding.
Your point is that if it had initially excluded the Oak transaction, then Goldman Sachs would have been challenging the August provision,
yes,
but would have been stuck with the proposition that it was binding unless and until it was overturned.
Exactly. They agree that, and Mr. Rabinowicz's submission, if you remember, was, well, the bank messed it up. That's actually the way he put it, which is a rather surprising submission in the context of a European directive and seeking to recognise how this operates across the EU. But that's what's being said. Oh, well, if you'd done it initially, that would be fine. But because you did it later, that's a mess up, and that somehow has to be ignored. Now, we'll come to it in a moment, but for your note, on the 11th of August, and it's in SFI Appendix Part 2, Volume 1, Tab 17, page 3245.
Sorry, say it again, say SFI.
SFI, sorry, I apologise. Yeah. Appendix Part 2, Volume 1, Tab 17, page 3245. Why don't we look at it now, otherwise I'll...
Right.
It's SFI Appendix Part 2, Volume 2. Sorry, I've given you the wrong one.
It's Volume 1, Tab 17.
Volume 1.
Volume 1, Tab 17.
Yeah. It's... Now, the detail of this doesn't matter, but what it's just important to understand...
Sorry, you're referring to...
It's SFI Appendix Part 2, Volume 1, my Lord.
Thank you.
And at tab 17 is the decision that was, it's minutes of a meeting of the board of directors of BDP at 5 p.m. on the 11th of August, and there's another one at tab 18 at 6 p.m. But what you can see is that the agenda item was to clarify and adjust the perimeter of the assets, liabilities, off-balance sheet items and assets under management of BESH transferred to Novo Bank. And you can see if you go to the next paragraph, under Article 146 of the law, and in view of the inevitable need for the measures taken by BDP in its extraordinary meeting on the 3rd of August, and you can see at 8 p.m. in the evening, this deliberation intended to clarify and adjust certain aspects of the measures referred to above is deemed urgent under the terms of the Administrative Procedure Code, and they proceed to make various adjustments to the way August is to operate. And then at page 3255 is an adjusted Annex 2A, I think. No, none of that, for present purposes, matters other than showing that you get the 1st, the 3rd of August decision, then in fact you get 2 decisions on the 11th of August, which are intended to clarify and adjust, and you see 3259 does the same. You then get, and we'll look at it in a bit more detail, on the 22nd of December, BDP's decision with which you're very familiar. Now, each of these decisions, my lords, the 3rd of August, the 11th of August, the 22nd of December, was, and this is common ground, as a matter of Portuguese law, valid unless or until annulled by the Administrative Court. Now, there is no distinction in Portuguese law as to the binding nature of any of them. They are all binding, they are all susceptible to review. But absent such annulment, the decisions, as a matter of Portuguese law, defined BESH, Novo Banco's, and Oak Bank's rights, Oak Finance's rights and obligations.
They're subject to review on a different basis, aren't they? If you were challenging the 11th of August decisions, or one of them, or the December decision, as I understand it, you could measure it, could you, against the August decision? Or I suppose if it purported to represent the August decision, then that might be a factor. If it purported to vary it, then you wouldn't measure it because it would be on its face a variation. But the August decision itself, there's nothing to measure it against.
No, there are other grounds on which you might...
Well, reasonableness and general...
Exactly, general...
discrimination
law
and so
grounds.
on.
Yes, exactly.
Yes. It's a different sort of scenario, but...
All I'm saying is the precise basis on which you might challenge doesn't matter.
No.
It's simply they're administrative decisions which are susceptible to challenges on different grounds.
Well, I think in the case of the December decision, what is said is that the December decision doesn't purport to vary the original August decision. Therefore, the challenge is...
I come back to why all of that is irrelevant.
Right.
The question as to the basis of the power. That's a confusion which is introduced, and it doesn't matter for the purposes of this decision. As a matter of Portuguese law, in our submission, come back to develop this, there's no question that subject to any successful challenge to the December decision, the Oak liability is a liability of BESH and not of Novo Banco, and the Oak liability was not transferred from BESH to Novo Banco by the 3rd of August decision. Now, what is important to bear in mind is that the appellants wish to contend, and they need to contend, that as a matter of Portuguese law, a transfer of the Oak liability from BESH to Novo Banco happened. And so one might be forgiven for thinking that in view of the December decision and its effect in Portuguese law, that was the end of the matter. But the appellants seek to sidestep the difficulties under Portuguese law and to contend that the English court is entitled, indeed I think they would say required, to consider the effect of the August decision without reference to the December decision. So by this route, they hope to achieve a result whereby the August decision is given an effect in English law, contrary to the effect that it in fact has in Portuguese law. So what they're inviting you to do is to ignore the true Portuguese position and to seek to treat Portuguese law in a different way to how it is treated in Portugal. Now, my Lord, bearing in mind that this case is concerned with the reorganisation directive, which is concerned with EU-wide recognition. It's very important. It is a recognition directive. The second directive...
Yes, I think we've got that. It's
is a
mutual recognition directive, not a harmonisation directive. And,
exactly.
Yeah.
But that's why this case is about the recognition directive primarily, and not about the harmonisation directive. But in our submission, because we're concerned with EU-wide recognition of measures taken by administrative authorities of a home state, it's a very odd suggestion that the English court should give a different effect to a measure taken by BDP to that which it would have in Portugal. And we submit that this approach that the appellants are urging on you is contrary first to the scheme, purpose and objective and requirements of the directive, the reorganisation directive, contrary to the tenor of the decisions of the European Court of Justice, contrary to common sense and fundamentally wrong. And the Court of Appeal were correct unanimously to reject the arguments. Now, the question ultimately is whether the European Parliament and Council, when they made the reorganisation directive, could have intended that it should operate in such a way such that a liability of a credit institution subject to reorganisation in Portugal should be treated in a different way in this court than it would be treated in the Portuguese court. And our case to that, our answer to that is simple and straightforward, and frankly none the worse for that. It should not be treated in any different way. My Lords, I want to now turn to how the...
I mean, your basic point is that the directive buys whatever is the local law.
Exactly.
And it's wrong to restrict the concept of what is bought to some theoretical or harmonised idea of what is a reorganisation measure, because what you are buying is whatever reorganisation measure is provided in the local law. I mean, I think the argument against you is, in part, that at a certain point, certainly by the time of the December directive, you're no longer talking about reorganisation measures at all.
Well, my Lord, with respect, I think we're confusing the different arguments. I'm, at this stage, looking at the effect in Portuguese law.
Right.
Of
you say that everything that relates to a reorganisation measure, including a variation administratively, is, so to speak, bought.
My Lord, before you get to that stage, I have our case is a simpler one. The question is, what in Portuguese law is the effect of the August decision? In Portuguese law, you can't answer that by failing to take account of the December decision. That's the simple point. You don't get, that's why the Court of Appeal were right to say, you don't have to consider at this stage whether the December decision is itself a reorganisation measure or falls within the definition.
I don't think that was very different from what I was thinking, but anyway, you put it.
Yeah, but there's a separate point. If I can just remind you of the way the Court of Appeal have put it. One is, when considering what is the effect of the August decision, you have to, as a matter of Portuguese law, you have to take account of the December decision. That tells you that the August decision did not transfer the Novo Banco, the Oak liability to Novo Banco. The second way the Court of Appeal put it was, in any event, you have to look at August and December together as part of a joint process, and that when you do that, it's perfectly clear that it is part of the reorganisation measure. But for the first way of looking at it, it doesn't matter whether in fact, you never get into that, whether December is a reorganisation measure. You're just asking yourself, what is the effect of August as a matter of Portuguese law? Now, my Lord, can I just make some points first by reference to the directive before coming back to these particular decisions? Now, the first point, your Lordships may want to have the directive open at this stage, so that's in Authority 1 at tab 1. Now, at page 1225, you'll remember there is the original definition of reorganisation measures. Now, when the August decision was passed, it was before the EBRRD had been incorporated into English law, because that happens in January 2015. The reference to that is in the Court of Appeal's judgment at paragraph 15. Now, but that didn't mean, because you didn't then have the extended definition, that didn't mean that the August decision was not a reorganisation measure which this court would recognise. The August decision fell within the broad definition that you see here of reorganisation measures, namely measures intended to preserve or restore the financial position of a credit institution. Now, it was also, in fact, a resolution measure under the widened definition. Now, in understanding how the reorganisation directive works, one of the key things is to look at closely the recitals which explain the purpose. And obviously not going to read things out, but it's important to look at page 1223 at recital 3, which is explaining the principle of unity, which is that a credit institution and its branches are a single entity subject to the supervision of the competent authority of the state where authorised. That's a reflection of unity. And then 4, again, is reflecting that unity. 5 is the policy of mutual recognition of reorganisation measures and winding up proceedings, being referred to in the last 3 lines. And then 6 and 7. 6 is referring to the administrative or judicial authorities having sole power to decide upon and implement reorganisation measures. And 7, the importance of ensuring the effectiveness of reorganisation measures.
And measures adopted to administer reorganisation measures in all member states.
Exactly. It's very, very broad policy objective. And similarly, Article 16 is important. You see, recital 16, I beg your pardon, equal treatment of creditors requires that credit institution is wound up according to the principles of unity and universality, which require the administrative or judicial authorities of the home member state to have sole jurisdiction, and their decisions to be recognised and to be capable of producing in all the other member states, without any formality, the effects ascribed to them by the law of the home member state. That's very important. You've got to look at what are the effects ascribed to the relevant measure by the home member state. Now, a similar statement of principle will be found if you go to the next tab to the subsequent directive at recital 119 at page 12 50, which enshrines the principle of unity, universality, and recognition. And it also shows that the EBRRD was intended to supplement and not replace the reorganisation directive. As you can see from recital 119, it states that the provisions of the reorganisation directive shall apply to the resolution tools. We know that Article 117, which you looked at yesterday at page 1379, it amends the definition of reorganisation measure, but it doesn't purport to replace it or state exclusively that reorganisation measures are now to be covered by this directive. Now, what this directive did was to provide for a minimum toolbox of powers of member states in circumstances where the financial crisis of 2008 had revealed that many states didn't have the equipment in their toolbox. And so the idea was to harmonise, at least to ensure that everybody had minimum powers. Now, if we can go back to the previous tab to Article 3, which is this much is common ground, this is, as well as the recitals, is important, you see it is drafted in a very broad way. So it refers to in the first paragraph, to the administrative or judicial authorities alone being empowered to decide on the implementation of reorganisation measures. We then see in paragraph 2 that the reorganisation measures should be applied in accordance with the laws, regulations and procedures available in applicable in the home member state. And if one applies that to our case, it obviously means that the August decision has to be applied in accordance with the laws, regulations and procedures of Portugal. Then the next paragraph, this is important. They shall be fully effective in accordance with the legislation of the member state. Now, the purpose of all of this is that the EU is using broad language to make it clear, in very simple terms, that the home member state is in charge, and there is to be no difference in approach in other member states from what is happening in the home member state. Now,
is that in effect saying this is more than a choice of law clause?
Yes,
provision?
absolutely.
That you have to read the first part of subparagraph 2 in the context of the article as a whole, which is saying that the home member state institutions control this process.
Yes, I mean that's precisely. And if it,
yes.
It's also saying, isn't it, that what one recognises is not just the specific measure directed to the reorganisation of the banks, but you also recognise those aspects of the general administrative law of the home state which bear on it.
Yes. I mean, and just stepping back for a moment, again, this is in accordance with both the spirit and the sense, and both common sense of all of this, in that what you don't want to have is arguments in different member states as to what the effects of the measures are. It's all meant to be governed by one single overarching provision, which is the home member state.
Well, the last thing is you want is, you would say, differences in outcome in different states. In particular, differences in outcome between the home state and the host state.
Yes. Now, these regulations actually do contemplate the possibility of appeals against decisions. And you'll see that in two places. Firstly, in this directive, in the first one, Article 6, you see it's headed publication. But what you'll see is that in one, where implementation of the reorganisation measures, etc., is likely to affect the rights of third parties, and where an appeal may be brought in the home member state, then goes on to say you've got to publish it. But then if you go to 5, what it provides is that the reorganisation measures shall apply, irrespective of the measures in paragraphs 1 to 3, and shall be fully effective as against creditors, unless the administrative or judicial authorities of the home member state...
Where are you reading from?
Sorry,
6.5.
it's 6.5.
Sorry,
I apologise.
Right.
So what that is making clear, the fact that there may be appeals doesn't mean that the measures don't apply. And this point, if you go to the next tab, is also addressed in the later directive at Article 66. And more pertinently, I think at 85, which you can see at 85.2 that member states provide for a right of appeal against a decision to take a crisis prevention measure, and that those effectively are the resolution type measures. But then 4 provides the right of appeal doesn't entail any automatic suspension of the effects of the challenge decision. Now that one can see is wholly contrary to the suggestion that my friend Mr. Rabinovitz was making, that for instance, where there's an appeal pending or some sort of challenge, and then one seeking to enforce or recognise a decision in this jurisdiction, the court somehow would form a view about the prospects of the appeal. Indeed, that's part of their overarching or submission here, which we say is wrong. Now, I want to... I suspect it's completely unnecessary to remind the court of the approach that one is required to take to the construction of European legislation, so I won't tax you by doing that. What I do want to do is to look at 2 decisions, but one in some detail, which is the Kepler case.
Can you just help me?
Yes.
Just so that we get the terminology right. This is an English law loan.
Yes.
Where was it actually made? Do you know? I mean, I was just asking myself whether the references to host state are relevant or apply.
No, those host state has nothing to do with the transaction. Home state.
Well, the host state is where the credit institution has a branch or provides services.
No, it's where it is for the purposes of regulation, where it is.
That's the home state, isn't it?
Yeah, the home state.
Sorry. I was saying what the host state. There's a distinction in terminology between home state and host state, and host state is defined in another directive as the place where a credit institution has a branch or provides services. Maybe we don't have to worry about it at all. But
I don't think anything, no, for these purposes, I don't think.
I mean, here, the loan was actually made subject to English law, but it was made in Luxembourg or where was it?
To tell the truth, I have no idea where it would have been made.
Right, may not matter.
Yeah.
The dollar loan, it must have been paid in New York.
Yeah. Right, anyway, carry on. You're going to go to the 2 European cases.
Your Lordship would appreciate, I'm acting for BDP. I don't know I'm not privy to what went on between Besh and...
Right.
Just before you go there, could I clarify your submission on Article 1?
Yes.
Where it says that the administrative or judicial authorities of the home member state shall alone be empowered to decide on the implementation of the reorganisation measures.
Yes.
How wide is that a conferment of a sole jurisdiction?
Sorry, could you say that again?
How is that conferring a sole jurisdiction on the home member state courts to decide on the implementation and effect of
Yes, in our submission, that's exactly what it's doing.
Well, it's not overriding exclusive jurisdiction clauses and so on. If there was a...
Sure, it means introduction is the word. Doesn't implementation mean introduction here?
Well, that's what I'm wanting to ascertain, just how wide is that provision?
It means they are the only people who have power to introduce reorganisation measures which not only apply in the home state but also in branches established in other member states.
Yeah, in my submission, it does certainly means that, but in my submission it's broader in that they alone are empowered to decide on, for instance, a question as to, like here, the December decision as to whether or not the oak liability was or was not within the excluded class.
Well, administratively that may be so, but you're not suggesting, I take it, that the effect is to give the courts of Portugal exclusive jurisdiction over this dispute.
No, not at all. No.
Because otherwise you wouldn't need a recognition provision.
No, we're not suggesting that.
I think that may have been the point of my Lord Doctor's question.
I just wanted to know how far you were going. That's fine.
Can we go to the decision of the European Court in Kepler, which you have in authorities at 1.7, page 1490. Now, this case is of some interest because it both shows the approach that the European Court of Justice says should be taken to the question, but also one sees some similar issues, in fact, having arisen. And
this case deals with retroactivity as well.
It deals with retroactivity. You'll remember there's a submission which wasn't developed orally that you can't have retrospectivity. The European Court of Justice says precisely the opposite to that. What happened in this case was that there was some Icelandic legislation to do with one of the well-known Icelandic banks. And the Icelandic legislative provision was called, you'll see, is called Law 44 of 2009. And Law 44 of 2009 amended the effect of a moratorium that had been imposed on LBI, Landesbanki. And the moratorium was a reorganisation measure. That's the important thing to bear in mind. The moratorium was a reorganisation measure, but the law 44/2009 was not. What the law of 44 of 2009 did was it amended the moratorium.
Where do we get that?
I'm going to show you.
Right.
I'll just explain what's happening.
Excellent.
And the court held the moratorium must be given the amended effect brought about by the law 44/2009, even though it wasn't a reorganisation measure. And can I show you the relevant part? The factual part that I've just been explaining, you'll be able to pick up from paragraphs 10 onwards. But if you go to paragraph 15, it explains what the dispute was. And if you go to paragraph 18, you can see that the French court found there that the law 44/2009 didn't refer to the particular article on insolvency, and furthermore, it didn't constitute a reorganisation and winding up measure. So the questions referred at 20 must Articles 3 and 9 of our directive be interpreted as meaning that a reorganisation or winding up measures in regard to a financial institution, such as those under Law 44, are to be regarded as measures adopted by an administrative or judicial authority for the purpose of those articles, and then second question at the moment doesn't matter. If we go to the first question, at paragraph 22, the court said, at the outset it must be borne in mind that as is apparent from recital 6 in its preamble, Directive 2001/24 seeks to establish mutual recognition by the member states of the measures taken by each of them to restore to viability the credit institution which it has authorised. The objective, and that of guaranteeing equal treatment of creditors laid down in recital 16, require that the reorganisation and winding up measures taken by the authorities have in all the other member states the effects which the law of the member states confers on them. And of course, I rely on that as being a very clear statement of the principle. Now, if you then go on to 27, it explains that, it's probably easy to read it, as is apparent from the file, the District Court at Reykjavik granted LBI a moratorium in accordance with Law 161/2002, as amended by later law, in order to enable it to reorganise its financial situation. And then 2 sentences on, it's not in dispute that moratorium, designed to enable LBI to reorganise its financial situation, constituted a reorganisation measure. Then the transitional provisions in Law 44 have amended the legal effects of these moratoria by making financial institutions under a moratorium subject to a specific winding up without those financial institutions being wound up before the expiry of that moratorium. The first question asked by the referring court must be answered in the light of these circumstances. In that regard, it must be borne in mind first that the administrative and judicial authorities are alone empowered to decide on the implementation of reorganisation measures for a financial institution on the opening of winding up proceedings. Second, in accordance with the second subparagraph of 3.2 and the second subparagraph of 9.1, reorganisation measures and decisions opening winding up proceedings are to have the effects which the legislation of the member state confers on them. It follows from that it's the reorganisation and winding up measures decided by the administrative and judicial authorities of the home member states, which are the subject of recognition, with the effects which the law of that member state confers. However, the legislation of the home member state relating to the reorganisation and winding up of credit institutions can in principle take effect in the other member states only through measures taken by the administrative and judicial authorities against a specific credit institution. As regards the transitional provisions in Law 44, it must be stated they amended the effects of the moratoria on payments which were in force at the time when that law entered into force. That preamble to that refers to grounds and objective relating to the various banks. And then at 31, you can see they say they introduced the applied to the credit institutions. And then 32 is important. Since the applicability of the transitional provisions was conditional on an individual decision granting or extending a moratorium, those legal provisions take in effect in accordance with the general scheme of Directive 2001/24, not directly, but through a reorganisation measure granted by a judicial authority for a specific credit institution. In other words, here, in this case, Law 44 wasn't a reorganisation measure, but because it was part of Icelandic law, which affected the moratorium which had already been imposed, which was a reorganisation measure, it did take effect because you had to apply the moratorium in accordance with Icelandic law. And so the so-called indirect route, which my friends referred to, was something which was specifically contemplated in this decision.
What does the first bit mean? Since the applicability of the transitional provisions was conditional on an individual decision granting or extending a moratorium.
I think it's referring back to what you see at the foot of the previous page. Paragraph 30.
Yes, I see. So the transitional provisions in Law 44 only apply to credit institutions benefiting from a moratorium.
And
with the result that unless a judicial decision has granted a moratorium, the transitional provisions can't operate, but they, yeah.
And then if you go to 37, you can see they deal with the argument that Mr. Giroux was putting forward, that as the transitional provisions of Law 44, which transformed the moratorium, are not a decision taken by an administrative authority, but rather legislative provisions, they cannot be the subject of an action and cannot be effective in the EU member states pursuant to the directive. And then they say, as noted in paragraph 27, the effects which reorganisation and winding up measures taken by the administrative or judicial authorities of the home member state may have in other EU member states are determined in accordance with the second paragraph of Article 3.2 and the second subparagraph of Article 9.1 by the law of the home member state. Therefore, that directive does not prevent that member state from amending, even with retroactive effect, the legal scheme applicable to such measures. So here you had Icelandic legislation which retroactively amended what was a winding up measure, and the European Court said that had to be recognised.
A reorganisation measure.
I'm sorry?
It retroactively amended a reorganisation measure.
Exactly,
yes.
exactly. And so it actually, our case is a far stronger case because what is actually happening here is it's the administrative authority, so you don't have this question about legislation, reaching a determination as to the effect of its prior determination, which as a matter of Portuguese law is binding. In our submission, that is something which, consistent with this decision, falls to be recognised. Now, the other aspect which is worth them picking up is if you go, this is under the heading of the second question, but if you go to substance on page 1499, I'd ask you to look at paragraphs 49 and you see the third line from the end where they say that the measures are to be effective when they are effective in the home member state. What the court is saying is that a measure is to be effective both in a temporal sense and to the extent that it is effective in the home member state. In other words, it would be completely inconsistent if you gave a broader or narrower effect to a reorganisation measure than that which it has in the home member state.
But that phrase is essentially paraphrasing the final paragraph of 3.2.
Yes. And you might also just want to note paragraphs 56 and 57. Now, in our submission, this decision, both what it says and certainly the tenor of the decision, is entirely inconsistent with the appellant's submissions in this case. Now, can I then...
It's quite a difficult decision. I mean, on one view, it's actually the transitional provisions introduced by the Law 44 of 2009, which are regarded as reorganisation measures.
Well, no, they're not. That's the decision is
the question says reorganisation or winding up measures, such as those based on the transitional provisions included in Law 44 2009. And the question asked is whether they are regarded as measures adopted by an administrative or judicial authority for the purposes of Articles 3 and 9, where those transitional provisions are effective only by means of judicial decisions granting a moratorium to accredited institutions.
The legislation cannot be a measure itself.
Yes.
That's one of the points that the court makes. So a subsequent piece of legislation is not
a measure. Yeah. Yes. Well, it can be a measure when it is brought into effect by a judicial decision granting a moratorium.
But the way the facts worked was the moratorium had been made by the court. Yeah. Then you had the law passed.
Right.
And the court was considering what was the effect of Law 44.
So how does it help you that this case is focusing on the effect of a law, which, as you say, can't itself be a reorganisation measure? Here, we are not dealing with a law. We're dealing with administrative decisions.
Because what the case is showing is that what you had to ask yourself is what was the state of Icelandic law in relation to the moratorium, and the subsequent legislation affected that position. And so you had to, in deciding what the terms of the moratorium were, you had to take account of the subsequent legislation. In other words, it's simply you had to look at Icelandic law. You couldn't look at the moratorium in isolation, which was part of, you've got to remember, that was the argument you see at 37, essentially what Mr. Giroux was arguing. That you had to ignore the law.
Yeah.
In terms of recognising it in France. And that's essentially what the French court, at paragraph 18, appeared to have done. But I rely on the case for the general statements of principle that you obtain, which is, in my submission, it shows that what you're interested in is the effects which the law of the home member state confers on the relevant reorganisation measure. And in this case, Icelandic law conferred particular effects as a result of Law 44 of 2009. In our case, we're going to come on and consider what is the effect of the August decision in Portuguese law. And my simple submission is that this court has to give it the effects which it has in Portuguese law. My Lord, can I move on to briefly just show you, but I won't spend any time on it, the Portuguese statutory powers, the legal framework. Or perhaps I can just give you the reference to them, because there isn't a dispute about it. It's in Core Volume 3 at tab 33, page 859. Just give you a quick roadmap of it. So, page 859 is chapter 4 on resolution, and at article 145C on page 860 is empowered BDP to impose resolution measures on a credit institution which was essentially in financial difficulties, and articles 145G, which is at page 865, and H, which is at 867, set out the detailed provisions for use of the power to use a bridge bank. At Article 145H1 was, I think, is the point that Lady Black was referring to, the power to select the assets, liabilities and so on to be transferred to the bridge bank. Then 2 provides for a prohibition on what can be transferred. So 1 gives a power to select, but 2 effectively fetters that power. And then 145 H5 on page 868 provides for transfer, essentially transfer back. So the effect of these various legislative measures is that BDP is empowered to impose reorganisation measures, including resolution measures, on a credit institution domiciled in Portugal in accordance with Portuguese law. Now, my lords, just stopping there, any measure imposed by BDP must be given full and consistent effect in accordance with its effect under Portuguese law throughout the European Union. Now, it is common ground that in purporting to exercise or exercising powers under Article 145 of the banking law, BDP acts as an administrative authority and decisions are administrative decisions which are binding. Now, if we go to the August decision in Core Volume 2 at tab 17, if you go to page 448, you can see what was on the agenda for this meeting. You can see it was at 8 p.m. in the evening, obviously a matter of some urgency. And you can see after the agenda items that measures have to be taken to safeguard the financial soundness of BESH and the interests of depositors and to maintain the stability of the Portuguese financial system, and the deliberations were considered urgent. You can see on page 449 the point that I was making. This is in the deliberations at 1, that they had suffered losses in the first half of 2014 of 3.5 billion euros. So, sorry, 3.5 billion euros. Then at 2, they make points about the ratios, the capital ratios and so on. We don't need to get involved in the detail. At 5, they make the point that it's essentially insolvent in a situation of severe liquidity shortfall. And from the end of June until the 31st of July, the liquidity declined by 3.35 billion. And it was impossible for them to raise funds. And then at 7, you can see serious breach of its obligations. And so they then take the decisions that we see being, we've looked at before, and at page 464, the Annex 2A at D excludes liabilities in accordance with what was required under Portuguese law. Now, and at 468, we've already seen the preliminary balance sheet. Now, in our submission, and I think this much is common ground, this was plainly a reorganisation measure, plainly was under both the original definition and the broader definition. But as such, it was also plainly subject to further determination, including whether or not particular assets or liabilities should stay in or out, whether particular assets or liabilities did or did not fall within the class. And in our submission, just pausing for a moment here, it would be absurd if the decision of the administrative authority whether or not a liability was within the excluded clause was binding in its home state, which it's accepted, here it is, and not binding across Europe. I've shown you the further August decisions. Can we go then to the December decision, which you have at the next tab? And what you have the decision at pages 471 and 471 and 473. But if you go to page 474, this is the report which the Board of Directors of BDP had before it when it was considering this question. So you can see at paragraph 1, and just stopping there for a moment, you remember there seems to have been a submission by Mr. Lord that there's some disconnect between the December decision and the August decision, that the two are not tied together somehow. Now that, frankly, it makes no sense whatsoever if you read the decisions. So if you see the background to it, at paragraph 1, what they're considering is that they made a decision on the 3rd of August, then they clarified and amended it on the 11th of August, which they together refer to the August decision, and then they explain at 3 in the report that there was an exception. Then at 6, what is explained is that on the date of the August deliberation, in the light of the known facts, Oak Finance was not considered as falling under one of the categories of liabilities not transferred. But they then say, however, after the resolution measure had been applied, BDP became aware of indications that linked Oak with Goldman Sachs, and they set out a whole lot of press notifications by Goldman Sachs indicating that it had in fact lent money, essentially statements to the market.
Press notifications by someone, not necessarily by Goldman Sachs, one suspects.
You'll see there are in fact notifications by Goldman Sachs as well. It's because then they say, I think there are two separate things. There's notifications by Goldman Sachs that they had more than 2% of the equity. You see that at paragraph 29 of this report. That's a notification they had made to BES, to BESH.
Right.
Then your Lordship is right that what's being referred to at 7 are indications from press reports about Goldman Sachs having lent money. Then they refer to, the detail for present purposes doesn't matter, to other material which led to the conclusion which they come to at 35, which is that the money has been lent by Oak acting on account of Goldman Sachs, and that they believe that Goldman Sachs had more than 2% of the shares. So that's the report that is being made. If you then go back to the decision, it's important to read the preamble to the decision. So if you go to 471 in paragraph 1, you can see that what is being recited is the earlier 3rd of August and 11th of August.
Sorry, which paragraph?
I'm sorry, page 471, paragraph 1 of the preamble.
Thank you very much.
So they're reciting that because they're making a decision in the context of the 3rd of August decision. And they then, having set out the further matters they're considering, we see the decision they come to at 473, that the BESH liability to Oak Finance was not transferred, decision's effective as of the 3rd of August, and the two banks must adapt which means amend their accounting records to the present decision and act in accordance therewith, and all of the parties are to be notified of the decision. Of course, at this stage, it's Oak Finance, because the assignments which the appellants in fact rely on happen at a later date. So one doesn't need to worry about the actual appellants at this stage. Now, just stopping there for a moment, just reading these documents, if one asks, well, what was the effect of this? What was plain on the text of the page, what was being said? It was that in the light of this administrative determination, the Oak liability was not transferred by the decision of the 3rd of August. That was what the whole purpose of this was, and no one could be in any doubt about that. Now, that decision was then first challenged by Goldman Sachs in dialogue with BDP, something it was entitled to do, and that resulted in the February decision, and that is in the next tab at 19, which you've already seen. And that also had a detailed report which started at page 501 to the Vice Governor. See, the subject is the information of the DJU and DE8, which are internal, on GSI's complaint regarding the BDP decision. And if you go to page 538 in the bundle, one of the issues in dispute raised by Goldman Sachs was whether it in fact did have this shareholding. And you can see at page 539 in the second paragraph on the page, one of the legal assumptions of this note was the assumption of truthfulness of the official disclosures to the market and the regulator in the holding of a participatory interest in a credit institution. The possibility of the bank establishing the amount of a participatory interest in terms which are factually divergent from those which the latter officially disclosed in the market would require an extremely high degree of evidencing certainty. The burden must necessarily lie with the interested party. What essentially the bank is saying, well, we're going to rely, and it's appropriate for us to rely on what you told the market. And at 542 are the recommended conclusions, and that fed through into the decisions at page 498 to 499. And you can see that at A, the bank on 498, 1A, the bank based itself on the disclosures to the market, A and B, and it was in that context when you get to I, about any doubt, margin of doubt or uncertainty, can only become uncertainty on the fulfillment of the premises for the prohibition of the transfer can only be overcome with a very high degree of certainty. That can only be reached with an entity with powers to reissue a final decision by a court of law. The requirement of a court ruling also results from the imperative of avoiding the creation of irreparable situation which cause an irreparable breach of statute. And so they conclude that they maintain the decision. Now, there are then challenges in the administrative courts by the appellants which remain pending. Now, can I get out of the way two, what I would suggest are false points? First is, there is the repeated suggestion that this appeal turns on the answer to the so-called underlying question, that is to say, whether the Oak liability falls within the excluded class. In our submission, it does not. That question is only relevant in the Portuguese administrative proceedings, and that is as to whether or not the December decision was made on an erroneous basis. Secondly, it's also repeatedly been suggested that this court should proceed on the basis that the appellants are likely to win in Portugal and will thereby succeed in annulling the decision of December. Now, in our submission, firstly, there is no basis for that submission. It is true that because of the way Mr. Justice Hamblin approached matters, whereby he considered one had to consider who had the better of the argument on the question as to what was the effect of the August decision considered in isolation, and he concluded on the evidence before him, the appellants had the better of the argument. But that was in the context where Novo Banco were not addressing the merits of the point, because their submission, rightly, was that the matter is governed by the December decision. So it's not appropriate in this court to be examining that underlying question. So it's not correct to say that that has somehow been examined. In any event, it's going to be a matter for the Portuguese court to consider all of the material. But the next point is that even if it were the case, the administrative court in Portugal concluded that the December decision had been reached on an erroneous basis, it does not follow that it will be set aside as night follows day, which I think is what's being suggested. Mr. Justice Hamblin actually correctly records the position, which is at paragraph 53.8 of his judgment, which is that the administrative court would have the power to set aside the December decision. But of course, whether it would actually depend upon a much broader inquiry. The reason it would depend on a broader inquiry is that, in fact, the December decision has been followed by subsequent decisions, and so the court would need to consider the overall utility of the position in the light of all of the decisions.
You mean the September decision to retransfer?
Exactly. Now, in our submission, the December decision could not be clearer. Now, what are the answers to it? The appellants say that the determination in December was not based upon some absolute conviction by BDP that the oak liability was excluded, but was based upon, as it says, upon there being serious and grounded reasons, page 471, to justify the understanding that it was excluded. Now that's true, that's what it says, but it's completely irrelevant. The fact that, to the question as to what is the effect of the decision, nobody says as a matter of Portuguese law that it makes any difference to the binding nature of this decision that you expressed yourself in saying there are serious and grounded reasons to justify this. It's a matter for the Portuguese court, ultimately, the administrative court, to consider. But what the December decision is not, and this is a point that was repeated again many times, it's not provisional, it's not temporary, it's not a suspension, it is a decision in the same way that any administrative decision is. It stands unless and until set aside. And indeed, Statement of Facts and Issues, paragraphs 47, 4 and 5 make that clear. Now, in the Kepler case, the court it's perhaps worth just turning it up again. Authorities 1 at tab 7, at page 1497, paragraph 40. Considered the question of whether it made any difference that it was possible or not possible to appeal. And so you see they say that in the context of the system established by the directive, reorganisation measures are recognised without any further formalities. In particular, the directive does not make the recognition subject to a condition that it be possible to bring an action against them. So what it's saying there is it's not necessary you actually have a right of appeal, but it's a fortiori, it's still enforceable even if you do have a right of appeal.
I thought that the EBBRD said it was necessary that there should be a right of appeal.
That's in
that's under different.
Your Lordship's right, but that's in relation to specific measures. Now, where the case has got into something of a muddle on my friend's side is as to what they are in fact saying about the December decision. If you go to Core Bundle 4, and you turn to tab 44, you have the witness statement of Mr. Baker on behalf of Goldman Sachs. And if you go to, just want to pick up two references, one at page 1060 in paragraph 34, and you'll see at the foot of that page, he says in the last couple of lines, I should make clear GSI's position that the nature of the December decision as a matter of Portuguese law is irrelevant. And if you then go on to 1069, at 46.4 on that page, the last sentence, specifically, the English proceedings do not ask the English court to consider the validity or otherwise of the December decision as a matter of Portuguese law. So, and just to pick it up, then at tab 48, your Lordship will find in the witness statement of Mr. East on behalf of the Mr. Rabinowitz's clients, at page 1112, paragraph 45, the last sentence, the same point. So it's just important to understand how the case has been proceeding. The appellant's position, understand the argument, they say the December decision is irrelevant. But what they also say is it's irrelevant, but I don't seek to challenge in the English proceedings its legality, validity, or effectiveness. So their position is, and that's, we seem to have got a bit confused in the submissions before this court, their position is that for the purposes of the English proceedings, and that's whether at this stage or at the substantive stage, they say the English court will not be required to consider the December decision at all because it's completely irrelevant. Now, that's essentially where what the question comes down to. Is it relevant or not? If it is relevant, then previously they effectively recognised that is the end of the case. Now, if you go back to the statement.
So, I mean, you say that the guaranteed trust point is really a new point here, I think.
That, I'm going to come to guarantee trust, why it's a new point and a bad point.
Yes.
But that is a new point.
The alternative way of putting it, to say that the December decision is not recognised because it's not itself a reorganisation measure, is consistent with what is said here.
Oh, they were certainly arguing that the December is not, I mean, that's always been their case. It's not a reorganisation measure, therefore, that's it. That's basically what they were saying. You just look at August, ignore December. Now but what they weren't arguing was, oh, well, somehow the English court, if I'm wrong about that, is to decide that December is invalid. That's crept in the course of the argument before your lordships, contrary to what you see being said here. Their whole case was it is irrelevant.
Well, I'm not sure. Were they saying it was invalid? They were saying it's not relevant because it isn't the final word.
Well, they were saying
Howard
it's going to be overruled.
Mr. Howard was not there at first instance, and that may explain why he's making the submission that he made. But you recall yesterday I explained that at first instance, which is what all this evidence relates to, there was no point being taken by Mr. Salter about Article 3 being relevant. Right. So it was never suggested that even if December is not a reorganisation measure, it matters. It was only when Mr. Howard came in the Court of Appeal and said Article 3 matters, that what one does about December, even if it isn't a reorganisation measure, began to matter.
How can Article 3 not have mattered?
Well, you should ask Mr. Salter that, but there was no attempt to...
It wasn't run, it was put on the basis that the December measure had to be a reorganisation.
It either said it was part of August, or it was of its own terms a reorganisation measure as a transfer.
Yeah. So, there we are.
Anyway, there we are. Your lordships will be able to see that, and I think Mr. Salter disputes that. But I wasn't there. I'm not going to argue about what was and wasn't said. More importantly, that we can see what their witness statements have said, but it doesn't matter because of the...
Well, again, you've got to look at them in context, haven't you? I mean, we've got to decide the points which are before us now, when nobody is suggesting that they're not in the arena.
My Lord, the more important thing is you've got to decide the case in the light of the principles of Portuguese law, which are agreed.
Yes.
That's the fundamental, and it is worth just turning up the SFI to remind ourselves of those. It's at Core 1, page 101 to 103. In fact, to the top of 104.
Paragraph, Mr. Howard.
Paragraph.
A different copy of this one.
I'm sorry, paragraph 47, my Lord.
Thank you very much.
Now, it is not in dispute that the December decision, and I'll show you what the experts, how Mr. Justice Hamblin dealt with it. It's not in dispute that it was an administrative act, and therefore is governed by what is in 47(4). And 47(5) and 47(16) equally apply. Now, what your lordships, what there is a danger of is getting sucked into a dispute, sucked into the question, which is a question for the Portuguese administrative court, which is whether or not BDP, what power it was exercising and whether it did exercise that power properly. Now, in other words, if you look at 47(12) and 13 and 14, you can see a number of ways in which an administrative authority, as a matter of Portuguese law, can take decisions. You can see it can reform, ratify, convert, revoke, amend, replace, interpret, and implement. So a number of different things that it can do. Now, precisely what BDP did within that menu, or whether it's outside of that menu, doesn't, for present purposes, matter. Because all that matters is that it did make an administrative decision which was binding. Now, if you go to Mr. Justice Hamblin's judgment...
When you come to a convenient moment, we'll have a 5-minute break, Mr. Howard.
Yes, of course.
Since it's a long morning. But
yes,
let's look at the Mr. Justice Hambling.
Can I just finish this point?
Yes.
And I'm just showing you this. Is that Mr. Justice Hamlin's judgment is in Core 2 at tab 16. And if you go to page 435, paragraph 59, this is why you don't need to get involved in the detail of the expert evidence and why it doesn't matter. You can see he said that the Portuguese law evidence disclosed 3 slightly different views. Sorry, I should have started at 58. There he refers to the December decision, that it purports to be a ruling there'd been no transfer. That's to say a declaration of what in the view of the bank had already happened. And the Portuguese law expert evidence disclosed 3 slightly different views of this. You've got Professor Duarte, that it's an act of confirmation or of revocation. Professor Almeida, a decision as a self-standing declaration, accepting it's an administrative act, not with the same standing as the August decision. Professor Moreira, possibly interpretive or implementing, alternatively revocative or reformative. So, in other words, you've got the entire menu being looked at, but then 60, all the experts nevertheless accepted that the December decision is under Portuguese law an administrative act, and even if annullable, the decision is prima facie binding and effective as a matter of Portuguese law upon the parties to whom it is addressed. So it doesn't matter for the purposes of recognition as to how the powers came to be exercised in Portuguese law. They are binding. And then, and that is in the context where at 53.4, His Lordship, and this is the same point that's reflected in the SFI, noted that an administrative act which defines a party's rights, that act is effective and the party's rights or obligations are as stated unless and until it's annulled. And so Mr. Lord's attempt to suggest somehow we're going behind the agreed propositions, on our side, we're not seeking to do that at all. We rely on the agreed propositions. What we say is the underlying dispute about how BDP came to exercise these powers is just irrelevant. What matters is that in Portugal, the December decision is directly effective and defines the parties' rights and obligations, and therefore tells you whether or not the August decision was effective to transfer the Oak liability, and it wasn't. Well, that's probably a good moment for our break.
We'll take a 5-minute break.
Lord, just having looked at coming back to the points on the December decision for a moment, the appellants appear to seek to argue that the December decision had no effect on the August decision. Now, in our submission, that it was both a tortuous submission, and indeed somewhat incoherent, in that, and I know Mr. Rabinowitz will forgive me, as we're good friends for saying that, but...
He would expect it.
That's what he expects.
We're good friends.
He knows me of old. But in the transcript yesterday, at page 83, lines 19 to 22, Mr. Rabinowitz said, I understand that what they sought to do, what it appears that they might have been doing, was trying to establish the position as it should be following the August decision. Well, frankly, that's right. They were establishing what the position was following the August decision. And at page 89, he said, at line 9, so again, as suggested earlier, it was effectively making a determination, so far as it went, that there wasn't a transfer to begin with. Now, this was in the submission, part of his submission, there wasn't a retransfer. But part of the difficulty is of the logic of the case, as my Lord Sumption pointed out. If you're saying there wasn't a retransfer, then what are you saying there was? Well, if Mr. Rabinowitz was right to say, well, it's a determination that there wasn't a transfer to begin with. If you say it wasn't that, then you fall into the retransfer. And there's no middle ground here. It's either one or the other. In fact, it's plain that what was intended was a determination that there had not been a transfer under the August decision.
But not by way of amendment of that decision. In other words, it was purporting to give effect to that decision. So presumably any administrative appeal would be reviewing the question whether in fact the factual basis on which the December decision was made was correct.
The point, that's right.
Yes,
I think the important, very simple point to bear in mind is this. Just as a matter of common sense, remember I started off this morning by saying, assume a slightly different scenario where when they make the August decision, they actually write in, we looked at Oak and we consider that that is part of the excluded category. Now, it's common ground that if they had done that, that would be binding subject to the appeal. Now, the effect, if one just thinks about it as a matter of common sense, what December is doing, it is then doing the same thing. It's as if you've written that in to the August decision because you're saying, I've now considered it, and this is the position.
I mean, a slight difference, isn't there? Because if it had been written into the August decision, it might have been quite difficult to argue that it was incorrect factually, and therefore there should be a correction.
No, it would be exactly the same point.
I say, if it had been written in expressly on the basis, because we believe it's more than 2% holding.
Yeah, because what you couldn't, it would obviously be, what you couldn't do is simply say, I'm going to discriminate against Goldman Sachs because I think they're a rich and powerful bank. Couldn't do that. Yeah. So that would be subject to a different review. So you have to treat creditors on an equal basis.
Yes, I see.
So you can't...
So what you're envisaging effectively is a sub-clause which says, and that includes Oak.
Well,
after the exclusion.
Yeah, exactly. And that in very simple terms, that is what has happened here. It's happened in Portuguese law. The decision is retrospective, and that's the important point. Because it's retrospective, it is now as if that had been part of the August decision.
Yes, but it was part of the August decisions that the excluded liabilities were excluded.
Exactly.
And so what you're in fact doing is saying we made a mistake in August in the provisional balance sheet by including Oak. Please alter the records because we now know, at least it appears, that Oak is an excluded liability. Yes. So you're just emphasising the decision which has already been made that excluded liabilities are to be excluded.
Well, it's going a little bit further than that because it's actually saying reaching a determination that oak is part of the excluded.
Yes, it is. It's a binding ruling.
Yes, that's right.
Subject to appeal.
Subject to appeal. Now, my lords, how, if I can just then take us back to the European regime and ask, well, how does all of this fit in with that? Now, we recognise, of course, that you start with, or you have to consider the August decision, because that's what the appellants base their case on. They're either in the August decision, it either gives them rights or it doesn't. But one then asks, as implemented and applied by BDP, and as in accordance with its effects in Portuguese law, does August have the consequence that oak was transferred to Novo Bank? And whichever way you approach it, whether you say as applied by BDP or the effect which Portuguese law gives to it, the answer is the same. It wasn't effective. If you look at Kepler, you ask what are the effects in Portuguese law of the August decision. That is, in our submission, clear. Now, this, when one's considering the EU directive, of course, where you've got to consider the position in Portuguese law, but you don't consider this by reference to considering, for instance, whether Portuguese law has a concept of implementing a decision. One of the experts says there's no such concept, but what you're considering is an autonomous European view as to whether what is being done is something which relates to the effects of the August decision. Now, in our submission, when you approach this case properly through the prism of Article 3, the December decision has to be taken into account as part of the law of Portugal, which has the effect of determining the August decision. And it means that the August decision does not have, and as a matter of Portuguese law has never had, the consequence of transferring the oak liability to Novo Bank. And in our submission, ultimately, this is all relatively simple. We've included in the bundles at Authorities 5, tab 46, 2858, an article, the Gardella article. The reason that...
Sorry, what was the reference again?
It's Authorities 5.
Tab
158, wasn't it?
Tab 46. And as BDP explained, the decision of Mr. Justice Hamblin, certainly greeted with dismay by it, but also by EU resolution authorities. And this article explains why the Court of Appeal judgment in favour of mutual recognition and cross-border resolutions fits in with the scheme. Now, can I turn to the appellant's specific objections? Now, firstly, the way in which the appellants have approached the matter before this court, which is to say you first have to ask whether the December decision is a reorganisation measure in its own right. Now, as the Court of Appeal noted, this is the wrong way round. The question whether the December decision is a reorganisation measure does not arise if we're right on how you approach August. See paragraph 28, I think it is, of Lord Justice Moore-Bick. Now, the issue is what is the effect of the August decision as a matter of Portuguese law and not some artificial construct of Portuguese law. And the position is similar to Kepler. Now, if we take the four critical objections, the first one was the August decision and the December decision have different and separate effects. And as I understand it, what the appellants say is that December does not determine the effect of the August decision. Rather, they say it has its own effect, which is somehow independent and separate from that of August. And so what they try to do is to split one off from the other. Now, this submission is both inconsistent with the agreed position in Portuguese law, but it's also inconsistent with the decision itself. The December decision, on its face, is it by reference to the August decision, and one can see what it is doing. But this is also an argument which does not reflect the approach which we suggest is required under Article 3. In our submission, the question that is appropriate to ask is whether the August decision was effective to transfer the oak liability as a matter of Portuguese law. And the answer to that is, as a matter of Portuguese law, it wasn't. And that's because that is determined by the December decision.
Can you just help me about the precise wording of Article 3 in
Yes.
2? In the first paragraph, it says that it should be applied in accordance with the laws, regulations and procedure of the home state. But in the next paragraph, the paragraph picked up in Kepler, it says in accordance with the legislation. A slightly narrower concept, possibly.
I think what the first paragraph is particularly looking at is that the home member state, for instance, decides how you're going to apply a reorganisation measure, on the procedures that apply and all that sort of thing. The second paragraph is then saying this is to be effective across the member states. Now, where it says in accordance with the legislation, that means the law of the...
So it includes the decision made here?
In our submission,
December decision.
Absolutely, yeah.
Takes its colour from recital 16.
Yes, and if you go back to recital 16, and in fact the way the European Court put it in Kepler, remember, recital 16 says it's to have the effects ascribed to them by the law of the member state. Ladyship, see that?
Yeah.
And in the Kepler decision, and in Kotnik, so Kepler is in volume 1 at 7, and I showed you paragraph 22 and paragraph 27, and you'll see in 22 they refer to the effects which the law of the member state confers, and 27 effects which the legislation confers, but the two are just used interchangeably.
They were dealing with legislation in Kepler, weren't
Yes,
they?
but there, that's right in 27, I suppose. But in the directive where it uses legislation, that is actually synonymous with law.
Okay.
And that point is also, I haven't taken you to it, but that point is also made in Kotnik, which you have in the next tab at paragraphs 104 and 105. It's 105 in particular. The objective entails that the reorganisation measures must have, in all other member states, the effects which the law of the home member state confers on them. they're referring across to LBI, but saying you've got two decisions of the European Court of Justice making precisely the point that you just look at what the effect is which the law of the home member state.
So the two were Kopnik, and what was that one?
The first one is Kepler,
Kepler, yeah.
looked at.
What was the paragraph there?
The paragraphs in Kepler
Yeah, don't worry, we
are
22 and 27 were the ones you
27
quoted.
yeah, fine.
and 28.
Yeah.
And then it's cross-referred to 105 of Kotnik. It's only cross-referring back to LBI. It's then got two decisions. Now, subject to the guarantee trust point, which I'm going to come to in a moment, but if one pauses for a moment and asks, well, there's a dispute amongst the Portuguese law experts as to what exactly was the basis for what BDP did. But let's assume for a second there wasn't a dispute between the Portuguese law experts, and that the position was that they were unanimous that, for instance, that the December decision was an amendment or a clarification of the August decision. Now, what would the position then be? Now, as we understand it, it is common ground. In that scenario, you would have to take the December decision into account in determining the effects of the August decision. And so the reason they appear to say you don't take it into account is that they dispute the validity of the December decision. But it doesn't make any difference for this purpose whether you accept the decision was one that was exercised pursuant to a proper power or properly done. So the characterization of the exercise of the power in Portuguese law in our submission is a red herring. Now, I next turn to the question, this foreign law point, the Johnny-come-lately point, which first surfaced before your lordship. Now, the way into this on the appellant's argument is that they say that as a matter of English conflicts provision, you can disregard December, or you can approach it on the basis that December will be annulled. Now, I've already shown you that up until the hearing before this court, they had proceeded on the basis that the December decision was valid. And Mr. Rabinovitz interrupted, don't mind him interrupting, but to say, well, I wasn't there before Mr. Justice Hamblin, that was right, and they tried to stop me being there in the Court of Appeal. But the point is, it's not just they were being unfriendly, they knew precisely what the points were that we were raising in the Court of Appeal. And they had plenty of time at that stage to raise these points, but they didn't. And so your lordships do have to consider whether at this stage of proceedings it is appropriate to perform this volte-face. Now, in our submission, essentially that's a matter for your lordships, but ultimately this point does not assist. And we say that for this reason. A decision of a foreign court on foreign law is treated as an expert opinion as to what the foreign law is. That's what the guarantee trust case is authority for. Now, the point in that case was, although there was a decision on a demurrer in New York, it was common ground in that case that there was no issue estoppel as a result of the New York decision. And so the New York decision was simply being relied upon as evidence as to what New York law was. And so what the court said was, well, that isn't binding on us, it's simply an opinion. Now, the December decision is not an expert opinion about Portuguese law. It is common ground that it is Portuguese law binding on these parties and continues to be such unless and until annulled by the Portuguese Administrative Court. Now, I've already shown you, well, it doesn't matter. The appellants rely on a principle that they say they derive from guarantee trust about temporary or defeasible decisions not having binding effect. In fact, that's not what guarantee trust is about at all. It's simply that a foreign judgment on a question is simply an opinion. Now, in fact, on the guarantee trust line of authority, even if you have a decision of the highest court in the foreign jurisdiction, that actually is not binding. Mr. Rabinovich suggested it was, but the bankers and shippers insurance case, which I'm sure is very familiar in the authorities volume 1, actually says the opposite. If you go to page 1417, what Lord Buckmaster said in the left-hand column about in the second paragraph on the page beginning having regard, he's dealing with a New York law statute, and he says about 10 lines down, it's a statute dealing exclusively with the question of procedure in a foreign court and has been considered by the highest judicial authority in New York. And though technically no judgment of a foreign court, even upon such a question as procedure, would bind this House, yet nonetheless the Committee of International Affairs would require special and unusual circumstances to lead this House away from a clear decision of a final court upon such a matter of construction. In other words, of course, you're going to pay it the highest respect, but in fact, it doesn't bind. It is obviously very difficult to contemplate in what situation an English court, if you had, say, a decision of the Supreme Court of the United States, would deign to say that was wrong as a matter of whether it was federal law or some particular state's.
It's put even more strongly in Carl Zeiss Stiftung against Rayner and Keeler, where exactly the same point arose, and there had actually been a decision of the highest court of the jurisdiction in question.
Yes. But at the end of the day, this is interesting, but completely irrelevant. And
before my learned friend puts that authority away, and I do apologise.
No, not at all.
Again, you're old friends. Can I invite my learned friend just to show you Lord Justice Atkinson at the bottom of page 1422, beginning with both these learned judges say they would shrink from doing, down to the middle of page 1423.
Sorry, the 1422 foot of the...
Column 2, bottom of the page, beginning with but what both his judges say, to the middle of left-hand column of 1423. And whilst I'm up, and I really do apologise to my learned friend.
No.
Just save some time in coming on my reply. Lord Sumner, page 1424, column 1, top of the page, and Lord Carson and Lord Wenbury, both at page 1424.
Well, perhaps the answer is to be found in Carl's Eichstift.
Well, it's also, the point is also made in Guarantee Trust at page 1440, and at the bottom of the page.
14.
Page 1440 in the bundle. At the bottom of the page in Guarantee Trust, where they say, it may be that we have, strictly speaking, the same power to consider a decision of the ultimate Court of Appeal. I cannot imagine an English court would hold a decision of the final Court of Appeal erroneous according to the law of that state.
Final Court of Appeal in the state of New York.
Yeah, because that was the question was a question of New York.
I know, but it is quite. I think it's quite important. Actually, it depends.
Well, I think that would be the final court on a state point. It may not. The reason I don't want to get bogged down in this, our principle.
Yeah, I'm sure it's the final court in the state of New York in the jurisdiction, but it reflects the respect given to the New York courts, which experience in this area. I suppose it might not always be the case.
No, I mean, obviously it depends on what the question is.
Well, we would be pretty astonished in this jurisdiction.
I'm sorry?
We would be pretty astonished in this jurisdiction if a foreign court were to say that the law that we had declared was not in fact the law of England.
No, precisely so. I mean, that's all. Our simple point is that actually Guarantee Trust doesn't. I mean, what is being put forward for is a submission that it's only the decisions of the final court that one would treat as binding. In fact, the position is even those are not strictly binding, although it's very unlikely one wouldn't pay them due respect. But the more fundamental point is that this line of authority doesn't have anything to do with this case, and that's our fundamental submission. And in particular, this approach is inconsistent with the scheme of the directive. The directive dictates that a measure taken, a reorganisation measure taken in the home state is to be, without further formality, recognised throughout the EU. Be completely inconsistent with that if a court in one state were to start considering, for instance, well, I wonder whether that measure was properly passed by the administrative authority. There would be no limit to this on the approach, and indeed that was ultimately Mr. Rabinowitz's response to Lady Black, that where they're challenging a decision of a reorganisation measure, then they're entitled to come before this court and say, well, although the challenge is in Portugal, you should not give effect to it because I'm going to win. In our submission, that, if anything, drives Trojan horses through these directives. It's that submission. That's all I wanted to say on Guarantee Trust. Briefly, you will have seen in the written case submissions made about retrospectivity. Mr. Rabinowitz's clients suggest that no reorganisation measure can be retrospective. This point wasn't addressed orally. It's manifestly inconsistent with the decision in Kepler, which I showed you. It's also the case that EU law provides for protections when legitimate expectations are infringed. This point was considered by Lord Justice Sales in the Court of Appeal, and he noted that there was no case being put forward that legitimate expectations had been infringed. And I think my Lord Mance put the point to Mr. Lord, who acknowledged that there wasn't anything that anybody had done as a result of the August decision such that it would be unjust to give effect to the December decision. So there's nothing in that. The next point they take is that we are somehow circumventing the Recovery and Resolution Directive. I think this is really a Mr. Lord point, and it's a bad point. The resolution, the EBRRD, the Recovery and Resolution Directive, is a minimum harmonisation measure. It's possible to adopt measures going beyond the strict confines of the directive, and providing they are reorganisation measures within the definition, they are entitled to recognition. There's no prohibition on retrospective measures, nor is there any prohibition on the way in which the administrative law of a particular state works. So the fact that in Portugal, the administrative authority, BDP, is able to make administrative decisions which have retrospective effect that may not be something that we have in our common law system, but the fact that Portugal has it is just something you have to accept as part of, or at least presently part of, the European Union, that we have different laws. So those are my submissions on really what is the true primary question here, which is, was August effective to transfer the liability? I then am going to turn, before handing over to Mr. Salter, to the question of the second way the Court of Appeal put it, which is that you should consider the December measure as part and parcel of the August measure, and therefore it is, in that sense, a reorganisation measure. Now, it's common ground that the August decision is a reorganisation measure. It's also self-evident that the December decision is on the same subject matter and is part of the same process. Now, when considering this from the point of view of the regulation, the directive, what you have to consider is whether collectively, together, these are the reorganisation measures. Now, it's not a question, as Mr. Lord, I think, was trying to put it, of Portuguese law. So I think he wanted to say, well, in Portuguese law, there's a dispute as to whether you view this as part and parcel of the same thing. But that's not the point. You're considering, under the EU directive, whether or not what has happened in Portugal amounts to a reorganisation measure. For that purpose, you have to consider, under the scheme of the legislation, whether the two decisions have to be viewed together. Now, we say, as a matter of Portuguese law, they obviously do, but also, obviously, as a matter of considering how the directive works. Now, I've already explained briefly that August was a reorganisation measure, and I'd just like to develop that a little bit further. In Kotnik, Authorities 1, tab 8, the court explained at paragraph 107 that reorganisation measure was a broad definition. Now, the reorganisation directive was designed to address two situations, and you can see if you go back to that in Authorities 1, tab 2.
Tab 1.
Tab 1, I'm sorry. I have it separate. In the second recital, you can see that it's considering the situation which arises if a credit institution runs into difficulties. And Articles 9 on page 1227 to 19 are considering the situation where immediate winding up is appropriate. Articles 3 to 8 are considering where efforts are being made to address the financial difficulties of the institution, but immediate winding up is not appropriate. So you've got the two types of measures, reorganisation and winding up. Now, what both of these are seeking to address is the perilous financial position of a credit institution that's run into difficulties. Now, when you're looking at the first type, or reorganisation measures, you could have measures which are intended to restore an entity to financial health. Others may be intended to preserve its financial position, and that may be preserve it in a way that is not intended to restore it to financial health, but to prevent immediate insolvency. Now, what is clear is that the August decisions, that's the 3rd of August, the 11th of August, and then the December decision, were part of a process aimed at addressing BESH's financial problems without allowing it to slip into insolvency immediately. Now, the Court of Appeal found that one of the purposes of these decisions was to stabilise the position of BESH pending its winding up and prevent a sudden collapse. Could I ask you to turn to the Court of Appeal's decision in Core Volume 2. At page 408. Paragraph 32, my lord. And paragraphs 32 to 34, the Lord Justice Moore-Bigg, with whom the other justices were in agreement, was considering this. And you can see at 32, he said, Mr. Rabinovitz submitted December did not fall within the definition of reorganisation measures because viewed in the context of the August decision to which it was ancillary, it wasn't a measure intended to preserve or restore the financial position of BESH. And he said the decision was the first in a series intended to culminate in liquidation. Mr. Howard contended that one of the purposes of August and December was to enable BESH to be wound up in an orderly manner, avoiding a sudden collapse of a kind that could have undermined the financial stability in Portugal more generally. Then Mr. Salter argued the reference to preserving or restoring the financial situation of a credit institution should be interpreted as extending to the financial activities of a failing institution. And then at 33, he quotes from Kotnik, and then at 34, having considered Kotnik, he said, given the circumstance in which the question arose, it's not surprising the Court of Justice held that burden-sharing measures were reorganisation measures within Article 2. Then in the next sentence, in the present case, the argument's more difficult, however, because there doesn't appear to have been an intention to maintain BESH as a going concern in the long term. The decision was no more than one element in a process leading to its orderly winding up. However, it is accepted that the August decision was a reorganisation measure, if only by virtue of its being a resolution measure, and it's clear that an important part of its purpose was to stabilise the position of BESH pending winding up. The December decision purported to clarify the effect of the August decision, and therefore was very closely connected to it. In those circumstances, I think it's to be regarded as, or as part of, a reorganisation measure and is entitled to recognition. In my view, to hold otherwise would undermine the scheme of universal recognition of measures taken by the home member state to deal with failing financial institutions. So, in our submission, that on that alternative basis, if you have to consider whether December is a reorganisation measure, at this stage of the argument we say it is, viewing it as part and parcel of August, that it's already one process. Mr. Salter will address you in a moment in more detail on essentially the case as to why the December decision can be a transfer back and why that falls within the directive. But just to conclude at this stage, the submissions on behalf of BDP, we submit that the Court of Appeal's judgment was correct, and in particular, I commend to you paragraph 28 of their judgment, where the court, after setting out the reasoning, if you look at the last 10 lines, where they explain that as a result of the December decision, the August decision had a more limited effect in Portuguese law than might otherwise have been supposed. But in my view, the English courts are obliged under directives and Regulation 5 to give it the same, I think he means Regulation 3, the same effect as it had under Portuguese law at the date when the issue arose. In other words, they're bound to accept it was not effective to transfer the oak liability. 29, I should have said, I think I have to correct what I said earlier, is where he makes the point you don't need to ask whether the December decision was a resolution measure. And paragraph 30, he deals with the submission that was being made, which essentially was the coach and horses argument. And on 408, he makes the powerful point that in the last few sentences, that if that object, which is the objects underlying the directive, are to be achieved, it's essential member states give reorganisation and resolution measures the effect they have under domestic law of the home state. If in the present case it were open to the English court to hold that the effect of the August decision is other than that which it has under Portuguese law, that would be a violation of the principle of universal recognition. In our submission, that is entirely right. And so, on that basis, on behalf of BDP, we invite you to reject the appeal, to say what I have been addressing are in fact what are the primary arguments. Mr. Salter will address you on the alternative proposition that the December decision, even if viewed as a standalone, is a reorganisation measure. My Lord, so those are my submissions, unless there's anything else I can assist you with.
Yeah. Mr. Jones?
Nothing from
Yes, Mr. Salter.
The court will give me a moment while I get to the... May it please the court has the written case on behalf of Novo Banco. Much of it has been covered by the learned friend Mr. Howard, and Novo Banco gratefully adopts his submissions where he has covered the matters that we're going to deal with. I'm going, if I may, to start with some introductory points about the scheme of the directives. Then I'm going to say just a very few words in supplement of what Mr. Howard has said about our primary case. Then I propose to deal with the three alternative methods by which we say the court should recognise the December decision, which arise if and only if the court is against us on the primary case. start with interpretation. And then Mr. Howard said he wasn't going to insult the intelligence of the court by inviting them to look at the principles of interpretation. I hope I won't do so if I encourage the court to look, not now, but eventually, at the extract from Bennion on statutory interpretation that we have in our authorities at Authorities 5, tab 47, starting at page 2862. The relevance of it is only this, that in listening to my learned friends, Mr. Rabinowitz and Mr. Lord, they, at several points, laid stress upon the particular wording of individual provisions of various of the directives. Now, this, of course, for those of us who started our legal training before the European law came into such widespread effect, is the familiar process of starting with the words of the statute and going backwards. But actually, under European law, as those extracts show, and as the court I'm sure will be familiar, one starts not with the words always, but one starts with the purpose, because European legislation has a long preamble in the form of its recitals, which set out the intention behind it. And the intention is often much more important than the individual words used, given that we have many languages in which the matter is dealt with, and also that the decisions are a matter of interpretation. All of this is set out, I think, uncontroversially in the extract from Bennion, so I won't invite the court's attention to it. But can I just give one example of that? An example that didn't in fact work. The court will remember that in the reorganisation directive, effect is given to the actions of judicial and administrative authorities. In Kepler, what was concerned was the acts of the legislature insofar as it revised a judicial act. The court decided it on the basis that the purpose of the legislation was to give effect throughout the community, throughout the Union, to the effects of administrative and judicial authorities, and therefore they couldn't treat the act of the legislature as a reorganisation activity, as something requiring to be recognised. But the Attorney General, if the court reads his opinion, took the contrary view on the basis, the Advocate General took the contrary view on the basis that the purpose of it was to give the effect of the foreign law as a whole to what had to be recognised throughout the Union. And therefore, you could read the words administrative or judicial authorities as if they included legislative authorities. Now, as I say, the court didn't follow him, but the Advocate General, steeped in the European approach to construction, did not consider that to be in any way out of contention. And that's an example of the European approach in which the interpretation is governed by the recitals. And that's important in this case, because we have crawled through some of the wording, and some of the wording is actually quite difficult to interpret. It's quite difficult to understand. My Lord Hodge, for example, has drawn attention to Article 3 of the Reorganisation Directive, which appears at various places to act as a choice of law clause. But actually, when looked at in the light of the recitals to that directive, plainly does much more. Lady Black has drawn attention to the fact that they use the word law, legislation in different places. Again, if one looks at the recitals, the intention behind the wording of those directives becomes much clearer. With that preamble, I come to my second point, which is this. The whole purpose of the Banking Reorganisation and Recovery Directive is to permit administrative authorities, not courts or legislatures, to do violence to the terms of commercial contracts. we've had this in English law via courts. We've had it since the 19th century. The Insurance Act 1882 permitted courts, as opposed to winding up an insurance company, to write down the value of insurance policies. But we don't have that administrative power. This is an unusual matter. But just as the Reorganisation Directive gave power to administrative or judicial authorities, in the Bank Reorganisation and Recovery Directive, it's the administrative authorities alone that are given the power, and the powers that they are given are to change the parties to contracts, to reduce the amounts of liabilities, to change the terms of contracts, all in the name of preserving the financial system and the other objectives of resolution. And so it's nothing to the point to say, well, the December decision, the August decision are merely decisions of resolution of administrative authorities. We are only looking at administrative decisions. That's the very point of it, that an administrative authority, by fiat, by administrative decision, is to have the right to make changes, not just to contracts governed by the law of their own state, but to contracts governed by the law of any state of the European Union. Because this directive adopts the principles of unity and universality. The process of resolution is to be conducted in the home member state by the resolution authority, and what it does is to have the same effect throughout the whole of the European Union as it does in the home member state. That's apparent from recital 119 of the directive and recitals 7 and 16 of the Reorganisation Directive. And that, we say, includes changes in the effect of the matter. Kepler is an example of a legislative change, which the Court of Justice of the European Union said changed the way in which the moratorium imposed by the courts was to be given effect. But to come back to my point about this being something conferred on administrative authorities, it is inherent in the nature of giving powers to administrative authorities that they are to have the powers under their national law which are given to administrative authorities. And those include, in Portugal and in most other of the states, the member states of the European Union, because they are mostly civil law countries, the power to make decisions which have immediate legal effects binding the parties to whom they are addressed. It is a matter of private law between them, but it is a matter of the law of Portugal. And that power is part of the law of Portugal. And when it says that it is to be given the same effect it has under the law of Portugal, that is part of that law. My learned friend, Mr. Lord, said, oh, but that can't be right because of the need for certainty. And he said, well, these are matters which come into the financial markets, so it's of extreme importance that parties should know with certainty where they are from moment to moment. Well, he's right to a point. It is important that they know where they are. But resolution, as we say in footnote 25 of our case, which is at core 111, page 308, is a process, not a single act. And this is recognised in the directive, not merely by the fact that part of the resolution authority is given power to exercise its powers from time to time and again, but actually by the description of why one needs to have an administrative authority in order to do it, because one is administering an institution which is in financial difficulties. Now, my learned friend, Mr. Lord, referred several times to the August decision as being a scheme transfer, and emphasised the importance of moving the business of the bad bank smoothly to the good bank under the bridge institution tool. But by definition, the bad bank is in trouble. It is almost certainly going to be either cash flow or asset insolvent, or about to become so. Simply moving all its assets and liabilities from one corporate entity to another corporate entity is unlikely to achieve anything useful. That is not the objective of the bridge institution tool. What is envisaged by the directive is not a scheme transfer such as might be effected under Part 7 of the Financial Services and Markets Act 2000, in which the business of an insurance company is moved over. It is the inevitably more messy restructuring of the business of a large financial institution to produce a viable part that can be hived off and eventually sold. And that can be seen very clearly from the detailed provisions of Title 4, Chapter 4, which are the bits which deal with resolution of the directive, which explains how the process of resolution is intended to work in practice. The learned friend Mr. Lord also emphasised, as part of his various coach and horses arguments, that there are a number of safeguards built into the BRRD, which simply allowing administrative authorities to act as administrative authorities would, he says, circumvent. Again, I don't disagree that there are safeguards, but it's irrelevant. The principal safeguard, funnily enough, in the BRRD is the no creditor worse off principle. The court sees that from recital 5. I don't think we've looked at recital 5, so perhaps I can invite the court to have Authorities Volume 1, Tab 2. It's page 1233. And it talks about ensuring the continuity of the institution's critical financial and economic functions while minimising the impact of an institution's failure on the economy and economic and financial system, provided that no creditor. The regime should ensure that shareholders bear losses first and that creditors bear losses after shareholders, provided that no creditor incurs greater losses than it would have incurred if the institution had been wound up under normal insolvency proceedings in accordance with the no creditor worse off principle as specified in this directive. And that is the bedrock protection which is provided, that whatever is done under resolution should leave a creditor no worse off than they are going to be if the institution, as opposed to going through a process of resolution, had simply been wound up.
Yes. Am I right to say there's a provision which has the effect that in the process of resolution, the institution has to calculate what the effect would have been in an insolvency if the assets had remained within the distressed bank, and if a creditor ends up as a result of the resolution measure with less than that, then he's entitled to compensation. Is that how it works?
Lord, indeed. The details are set out at footnote 6 of our case. But if I can just invite your Lordship's attention to that, I can just go through the provisions quickly. First of all, recital 50. Again, I make no apology for starting with recitals, because those are the things which tell you what the operative provisions are supposed to be doing. Recital 50, interference with property rights should not be disproportionate. And then they go on, in the event of a partial transfer of assets The residual part should be wound up under normal. In order to protect shareholders who are left in the winding up proceedings of the institution, they should be entitled to receive in payment of or compensation for their claims in the winding up proceedings not less than what is estimated they would have recovered if the whole institution had been wound up under normal insolvency proceedings. And that's given effect to by Articles 34(1)(g). Perhaps I can just give the court the notes to this. Article 73, Article 74, which is the valuation article, and Article 75. Perhaps we can just look at Article 75 because it says specifically this. Member States, it's on page 1344. Member States shall ensure that if the valuation carried out under Article 74 determines that any shareholder or creditor or the deposit guarantee scheme has incurred greater losses than it would have incurred in a winding up under normal insolvency proceedings, it is entitled to payment of the difference from the resolution financing arrangements. The other provisions also say that individually, at each stage, you have to value the what is being done and make a comparison. And Bank of Portugal, in fact, did that and provided for valuations in the present case. So there are undoubtedly safeguards. But the issue, we say, is who polices these safeguards. And therefore, whether they're conditions to universality, conditions to recognition, or merely matters giving rise to remedies in the home member state under domestic and/or EU law. The answer to that question, we say, is to be found in recitals 88 to 91, which are at page 1246. And may I, with apologies, invite the court just to look at those again. Recital 88 says, in accordance with Article 47 of the Charter, that's the Charter of Fundamental Rights and Freedoms of the European Union, the parties concerned have a right to due process and to an effective remedy against the measures affecting them. Therefore, the decisions taken by the resolution authorities should be subject to a right of appeal. Then it says, crisis management measures require complex economic assessments and a large margin of discretions. The national resolution authorities are specifically equipped with the expertise needed for making those assessments and for determining the appropriate use of the margin of discretion. Therefore, it's important to ensure that the complex economic assessments made by national resolution authorities in that context are used as a basis by national courts when reviewing the crisis management measures concerned. However, the complex nature of those assessments should not prevent national courts from examining whether the evidence relied on by the resolution authorities is factually accurate, reliable and consistent, whether the evidence contains all relevant information which should be taken into account in order to assess a complex situation, and whether it's capable of substantiating the conclusions drawn therefrom. Since this directive aims to cover situations of extreme urgency, and since the suspension of any decision of the resolution authorities might impede the continuity of critical functions, it's necessary to provide that the lodging of an appeal should not result in automatic suspension of the effects of the challenge decision, and the decision of the resolution authority should be immediately enforceable with a presumption that its suspension would be against the public interest. In addition, where necessary to protect third parties who have acquired assets, rights and liabilities of the institution under resolution in good faith, by virtue of the exercise of the resolution powers by the authorities, and in order to ensure the stability of the financial markets, a right of appeal should not affect any subsequent administrative act or transaction concluded on the basis of an annulled decision. In such cases, remedies for a wrongful decision should therefore be limited to the award of compensation for the damages suffered by the affected person. Now that's given effect to by Article 85 of the directive, which the court has seen. Perhaps I can just invite the court to look at it again. It's on page 1352. and start at subparagraph 2. Member States shall provide in national law for a right of appeal against a decision to take a crisis prevention measure or a decision to exercise any power other than a crisis management measure under this directive. Can I just invite the Court's attention to the limited nature of the definition of crisis prevention measures, because I don't want to overstate our case on that. And that requires to go back to page 1261. And it's at the top, it's definitions 101 and 102. And they don't actually include the application of most of the resolution tools. They're concerned with the right of immediate preemptive action and things like that. But Article 85(2), to come back to it, speaks of an right of appeal against a decision to exercise any power under this directive.
Which doesn't include the reorganisation directive.
That doesn't include the resolution aspects of it, my Lord. Even in the case of crisis prevention measures, Article 3 says the right of appeal is there, and the lodging of appeal shall not entail any automatic suspension of the effects of the challenged decision, and the decision shall be immediately enforceable, give rise to a rebuttable presumption that suspension of its enforcement would be against the public interest. And then it goes on to say, where it's necessary to protect the interests of third parties acting in good faith who've acquired shares, etc., under resolution, the annulment of a decision of a resolution authority shall not affect any subsequent administrative acts or transactions concluded by the resolution authority concerned, which were based on the annulled decision. Again, in that case, remedies for a wrongful decision or act by the resolution authorities shall be limited to compensation for the loss suffered by the applicant as a result of the decision or act.
That's limited to crisis management measures.
Well, my Lord, not in terms.
Well, it refers back to the appeals referred to in paragraph 3, which is so limited, I think.
So what's the application of this, if any, in the present case, or is it just inspiration?
Well, my Lord, first of all, Lady Black raised the question, I think, perhaps it was my Lord Sumption, I'm sorry, as to what the grounds of challenge of BDP were in Portugal. The learned friend Mr. Howard quite correctly said that they were challenges under Portuguese administrative law, but among the other challenges that one sees there are the suggestion that Portuguese law has not correctly transposed the BRRD, that the BRRD is otherwise of direct effect, there is a breach of the Portuguese constitution, that there has been a failure to operate the banking law. They're all set out in the index to the complaint made by them. So it is a complaint brought under Portuguese law. The point I'm making, my lords, is simply this, that as the court has seen from the recitals, the recital not being limited to crisis prevention measures, the recital being generally to that there is a presumption in favour of the decisions of administrative authorities being effective according to their terms, and the remedy for them getting it wrong, there being a right of appeal, presumptively being compensation, not an annulment of the decision, because it is necessary for the purposes of resolution that parties should get on with it.
But are you suggesting that these are directly applicable? If you can show that there was a decision to exercise a power under this directive, and I think that is one of your possible cases, then I can see that this might be directly applicable. Otherwise, it doesn't seem to be.
Lord, yes. What they're talking about, though, are the acts of administrative authorities.
Well, they're only talking about some of them.
In a certain context, that's what it's. That's
Lord,
why I'm
yes.
asking, what is the context in which you say these are applicable? exercise of a power under this directive, well, I think you may be arguing that the power was exercised, possibly an Article 66 power. But otherwise?
My Lord, may I feed that in, as it were, to what I'm going to say about our principal argument? But I'm dealing at the moment with my learned friend Mr. Lord's point that there are safeguards. And what I'm saying is that the safeguards, assuming that one is looking at the directive, the safeguards in relation to this, are not conditions to universal applicability. They are matters to be policed by the courts of the member state. Those courts are themselves part of the European legal structure and under the treaties are subject to the jurisdiction of the Court of Justice of the European Union. And as my Lord Justice Sales said in the Court of Appeal, in the event that those courts don't give relief to which the party would be entitled under European law, then the Court of Justice of the European Union will supervise that and will rule.
Well, not exactly, but
yeah.
We can make references, or should make references, in certain contexts.
Absolutely. My Lord, if it's the highest court and there is a matter which isn't act clear, then there is a treaty obligation.
We seem to be straying a bit, though, from, I think, the issues which are ultimately going to focus on.
My Lord, I wasn't dealing with the question of this court, merely that the safeguards here that are built in are part of what we submitted in our case, the full faith and credit which has to be given by the other member states of the Union to the institutions of the home member state, part of the principle of unity and universality.
All right. Well, I can see that's the article you were looking at is a reinforcing article in that general sense.
My Lord, yes. And I was simply illustrating it by the fact that the courts eventually are subject to the supervision of the Court of Justice of the European Union, which guarantees the rights given by European law. Therefore, if it's said that there is no remedy, that these safeguards aren't being honoured, actually what it does is it puts the responsibility for policing the safeguards upon the national constitution and the national courts, subject to the ultimate guarantee of the CJEU. My Lord, can I just, in the 2 minutes left before the court rises, just look at the practicalities of this? And look at the position that the Bank of Portugal found itself in December 2014. It was conducting the process of resolution of Banco Espírito Santo. That process involved running or directing the running of a new financial institution, Novo Banco, attempting, because the directive requires it to do this, to sell Novo Banco or to wind Novo Banco up within limited periods of time subject to supervision. That's the way the bridge institution works. There is a provision that you can't just leave it there. Because of the prohibitions on state aid, you can't leave it dependent upon the public purse. It found, as a result of its investigations, so those reports that my learned friend Mr. Howard showed to the court, that there was evidence that the Oak liability was an excluded liability, not least the report to the market made by GSI that it owned more than 2% of the shares, and the other matters that are referred to in that. There was therefore uncertainty as to whether the liability was or was not within. It thought it probably wasn't, but nevertheless the matter had not been finally resolved. It would have been possible for that matter to be resolved by a court, no doubt. On the other hand, the logical and sensible person to resolve that uncertainty was the administrative authority entrusted with the process of resolution, viz. The Bank of Portugal. It made a decision. That decision was immediately effective and formed part of the resolution process. course, Bank of Portugal couldn't preempt the decision of the administrative court, but it could practically resolve the situation, leaving any parties injured by the decision to appeal, in practice to challenge the decision before the administration courts, and to claim compensation. And that brings me, just before I sit down, to Mr. Lord's point that the counterparty in this case is a will-o'-the-wisp, that the liability is courtless, he doesn't know who to sell. Actually, of course, that's not right. Under Portuguese law, there is no will-of-the-wisp at the moment. The liability is Besh's. He can claim against Besh. If, as a result of Bank of Portugal's decision, they've suffered loss, and if that decision was wrong, they can claim compensation. That's the way the directive works. Indeed, they have claimed compensation, as well as the annulment of the decision. But the proper respondent to a claim under the facility...
You might like to identify the precise article which you say applies or would apply to give them compensation as a matter of interest, but do it after the adjournment.
Lord, I'm grateful.
Yes. So we'll resume at 2 o'clock.